Elon Musk has launched a thermonuclear lawsuit at Media Matters. And in this episode, we are going to talk about exactly what that lawsuit entails. We're going to talk about the parties, the claims, and whether or not it has a shot at victory. So hang in there and strap in for this episode of The Legal Mindset. This is, of course, The Legal Mindset, where you can be your own judge. Let's start with the parties. So we actually have three parties, two corporate entities and an individual. So the corporate entities on the plaintiff's side is X. X is a corporation, the successor entity to Twitter, so they can make all the same claims that Twitter did. It's just a change of the name. It's been the same entity, has not fundamentally changed or in any way would prevent them from making a claim for the past, versus Media Matters and Eric Hinoki. Now, Media Matters is an extremely political active organization that has a known and admitted left-wing bent. They are very much against anybody who does not fall in line with the current thing, with essentially every single word coming out of Barack Obama or Joe Biden's mouth. You've got to follow it to the T, or Media Matters is on you like a dog on a bone. Now, Eric Hinoki is, of course, one of the crazed minions, a writer for Media Matters, who wrote a particularly harmful article that is the subject of these claims. Now, this is something that's very important, is that typically you have to sue in the actual state. But because X has significant activities in Texas, and because they have things that are going on in Texas, even though they were headquartered formerly in California, and even though Media Matters is in DC, they're trying to bring a diversity case in Texas, a federal case. This is at the federal court level. And because they're not from the same state, you can bring it in federal court. And because there is enough activity in Texas, they're able to claim, hey, it's hurting Texas. It's violating Texas law as well. So, hey, we're going to go over here. We're going to bring this claim in Texas. So this is a federal diversity case. Let's start with that one. Now, let's move on and get into the facts. What actually happened? So here's a summary of the facts. Media Matters published an article, and in that article, they claimed that major brands had their ads appearing next to neo-Nazi content, that this was something that was happening regularly, happening routinely in the X platform, on the X platform, rather. They were claiming that neo-Nazi stuff, anti-Semitic stuff was popping up next to these ads. As a result, many major companies pulled their ads from X. So X lost a ton of major, and we're talking major, huge companies that dropped X because they said, well, they're being discriminatory, right? They're putting our content next to anti-Semitic stuff, next to hateful stuff. Mostly it was stuff related to, let's say, a period between 1938 and 1945. There's a lot of that sort of stuff. And they were putting that out there as a serious claim. Well, here is the issue, which is something that X brought up in its complaint. These weren't actually real results. These were highly manufactured. They were manufactured in such a way with such a low statistical probability that the only way they can happen is by essentially forcing it to happen. The only account that saw any of this was the Media Matters account itself. So no other accounts other than Media Matters itself saw these ads. This is not something that was happening to anybody other than the one account which engineered it by specifically following brands and then anti-Semitic content, and that's all. So all they did was they followed major brands and then anti-Semitic content, and they constantly refreshed. They refreshed at a rate that was insane in order to finally generate an ad that was next to the anti-Semitic content. So it wasn't even something that you could get normally or that you would generate normally. It wouldn't be possible to do that because nobody is following both major brands. No one's following Disney, but also following Nazis. That's not really a thing, right? So, well, they might be following Gavin Newsom or Joe Biden. So I do take that back. They might be following a couple Nazis. But that aside, it's not something that is typical. And because of that, it's defamatory because, right, and we're going towards the claim, but it's part of the facts. The allegation is that, hey, look, you see these advertisers that left, and they factually left. They factually dropped their advertising from X. They've gone away. This is a major hit to their revenue, a significant percentage of their revenue. There are damages to X. These damages would not have happened but for the article posted by Media Matters and the writer Eric Hinoki. So this is exactly the facts that we get into with this case. Now, let's cover the causes of action. There are 3 causes of action in this case. Number 1 is interference with contract. Many people have heard this more specifically as tortious interference of contract. This is something that is quite common in business litigation. Tortious interference of contract typically comes up when another party knows you have a contract and goes out of their way to mess with that contract. So let's say that you buy oranges from Farmer Bob, right? And you have a nice relationship with Farmer Bob. You've been buying them from Farmer Bob forever, buying his oranges. They're good oranges. Well, all of a sudden, the jealous neighbor of Farmer Bob comes out and says, did you know that Farmer Bob is running a crack house? Right? Did you know that he is dealing drugs out of his farm? And you're like, well, I didn't know that, but I can't have anything to do with that, right? So you break your contract based on that information. And the neighbor, it turns out, knew about your contract. He knew you guys were making money off this. He knew that there was a business arrangement there, and he did it anyways. Well, that's going to be tortious interference with contract, particularly if it's not true, right? If what was said is factually inaccurate, yeah, that's going to be a problem. Now, if it's factually accurate, that's obviously a defense, right? If it's truthful information, if you're providing truthful information, that is not a problem. The truth is always protected. However, in this case, if it's not, right, if it's not true, you can have liability. So all of these companies, all of them that they had contracts with, advertising arrangements with, business relationships with, those were interfered with, and therefore that is why X is alleging tortious interference with contract, or rather, more simply, interference with contract as cause of action number 1. Cause of action number 2 is business disparagement. Now, business disparagement is a little bit zoomed out. You're going to actually zoom out when you look at business disparagement because it's something that's looking at more of the overall reputation of the company rather than just interference with any one specific contract or a series of contracts. It's looking at the corporation as a whole, so X as a whole, and saying that factually they are putting anti-Semitic content next to major brands. That's what they're factually doing, when that is not the case at all. In fact, that's complete fabrication. They are not putting it intentionally. They are not going out there and putting it even as part of the algorithm. In fact, it's not something that can happen because you can really opt out, right? So these companies can opt out of appearing next to certain types of information. They can say, I don't want to appear next to ads for anything gambling related, right? I don't want my content to be appearing next to that. Okay, and they'll do that, right? X can filter that out for you, right? There's adult creators on X. This is one of the famous things about X is that they actually allow adult creators. They allowed it under Twitter days. It's no change in policy when Elon took over. But you can say, hey, I don't want my content to appear next to anything adult. And they'll do that for you. They'll screen that out for you. So going out of your way to create anti-Semitic content, to create hateful content, and then saying, oh no, this is normal. This is what happens when you go on X. You just get put next to anti-Semitic content because it's everywhere. It's a complete fabrication. The only people it happened to was that account. They forced it to happen when it really shouldn't have happened even once was so statistically unlikely. But because they forced it, they generated one instance of it, and that was it. No proof it's ever happened anywhere with any other account. So that's business disparagement, making X appear as if it's an anti-Semitic platform, which of course is not true. And it's obviously an attack on the platform based on Elon taking over and being an advocate of free speech, whereas Media Matters has been very clear. Media Matters is very pro-censorship. They are very, very, very pro cracking down on free speech. Okay, number 3. 3 is interference with prospective economic advantage. Now, this is a little bit more of a kooky cause of action, but essentially it's looking at the economic relationships and the potential economic benefit to X. So X had those relationships, they pulled it from them, therefore they're losing out not just on the past revenue, current revenue, but also future revenue. So they're losing out on all of those lucrative future contracts, the lucrative potential relationships in the future. That's prospective, right? So looking into the future. So they're able to come in and claim damages for all of those relationships going into the future. So this is something that really opens the cap. It takes the top off from a liability standpoint and just launches the absolute nuke at Media Matters, because they can potentially face massive liability under this third cause of action, which is why Elon and X included it in their complaint. Now, let's talk about who's going to win. I know that's what you guys want. You just want the call, you want the prediction, and of course, your boy, Legal Mindset Andrew Esquire, never holds you up. But before I go anywhere, I'm going to hold you up for a second. And that's for you to like this video, smash a like button on this video, share it out there. But the most important thing is hitting that like button, because it lets people know we are out there in the algorithm, lets them see this video, and lets them know that we're producing good content on this channel. Stuff like Media Matters. Okay, here's my call. It is a very difficult fight to win a defamation case. So the bar is against Elon. It is going to be a tough battle just based on proving these types of claims. These types of claims are very hard to prove. So overall, the burden is against Elon. However, within that burden and acknowledging that it exists, Elon does have a strong case based on the facts. Looking at the facts as presented and the true damages, which are massive here, yeah, there is an actual case here. This is not something that's going to be thrown out on a motion to dismiss. I know some crazy, kooky leftist, CNN and et cetera, might say, oh no, it's going to get blown out. Absolutely not. This is another bad take, much like the Disney case, where their personal bias against Elon is seeping through, right? That personal bias is getting in the way of their objectivity. Objectively, this is a strong case. I would give it a good chance to prevail. I don't want to say 50-50, but there's a good chance it can prevail. There's a very solid chance. I want to put it somewhere between the 40 to 60%. We're somewhere in that range. It can fall on one side or the other, depending on the evidence presented. What do you guys think? I want to know in the comments below. Do you think Elon's going to prevail? Do you think Media Matters will win this one? Let me know. And if you want me to continue to cover this, please leave that in the comments so I know you want me to follow this case. Until next time, guys. Peace.